All right, welcome to this explainer. Today, we're diving deep into a really detailed case digest of a landmark Supreme Court decision. We're talking about Locsin v. Hizon, GR number 204369, handed down in 2014. If you're a law student, a practitioner, or honestly anyone in real estate, consider this a masterclass in the vulnerabilities of the Torrens system. We're going to break down a pretty complex property dispute that tests the absolute limits of the innocent purchaser defense and the very foundation of land titles in the Philippines. So, let's jump right in.
Here is our roadmap for today. We'll go through 1. The stolen title. 2. The Mirror Doctrine. 3. Red flags of bad faith. 4. The suspicious sibling sale. 5. Precautions for land buyers. And 6. The Supreme Court verdict. But before we lay out the facts, I want you to really think about this for a second. Can a completely forged deed ever actually create a valid land title? Well, under the Philippine Torrens system, the answer might actually surprise you. The law definitely protects the sanctity of a certificate of title, but as you're about to see, that protection is absolutely not a shield for people who just turn a blind eye to reality.
Section 1. The stolen title, or the heist of TCT number 2350945. Okay, so the story starts with Enriqueta Locsin. She was the registered owner of a 760 square meter lot in Quezon City. And what happened to her is basically a calculated paper trail heist while she was living in the US. Let's look at this timeline, because the sequence of events is absolutely critical. In 1992, Locsin filed an ejectment case against an occupant on her land, and they reached a court-approved compromise agreement in 1993. Then, Locsin leaves for the US. Fast forward to 2002, and she finds out her title is just gone. It turns out a woman named Mary Lou Bolos had canceled Locsin's title back in 1999. Using a supposedly executed deed of absolute sale that dated all the way back to 1979. Bolos then immediately sold the lot to Bernardo Hizon, who titled it under his son Carlos's name. When Locsin discovered this whole mess and demanded her land back in May 2002, the property was rapidly flipped again. As any legal practitioner knows, these dates are the smoking gun.
Naturally, Locsin sued. She filed an action for reconveyance and annulment of title. But shockingly, both the Regional Trial Court and the Court of Appeals dismissed her complaint. The lower courts basically completely failed her here. Even though the CA rightfully acknowledged that Locsin's signature on that 1979 deed was a blatant forgery, they rigidly applied what's known as the Mirror Doctrine. They ruled that the subsequent buyers, the Hizons and their relatives, were innocent purchasers for value who could rely strictly on what was written on the face of the Torrens title.
Section 2. The Mirror Doctrine, and going beyond the certificate.
So how in the world could the lower courts let a forged deed defeat the true owner? Well, it all rests on understanding who exactly an innocent purchaser for value is. By legal definition, this is someone who buys property without notice that some other person has a right to or interest in it, and who pays a full and fair price before receiving any notice of someone else's claim. Jurisprudence actually dictates that a defective or forged title can technically be the root of a valid title, but only if the buyer is an innocent purchaser for value relying in good faith on the Torrens certificate. And that, in a nutshell, is the Mirror Doctrine.
But here's where the Supreme Court stepped in and corrected the appellate court's rigid stance. The court delivered a massive, crucial reminder. They stated, quote, "The presence of anything which excites or arouses suspicion should then prompt the vendee to look beyond the certificate and investigate the title of the vendor appearing on the face of said certificate." End quote. That word suspicion is the absolute hinge here. If you ignore obvious red flags, you cannot claim to be an innocent purchaser for value. You literally forfeit the protection of the law.
Section 3. Red flags of bad faith. Unpacking the absurdity.
Let's put on our litigator hats for a second and unpack the respondent's claims. Because when we actually look at the facts that Bernardo Hizon knew at the time, his whole defense of good faith completely crumbles. Look at this glaring contradiction. Bernardo Hizon actually admitted in court that he knew about the 1992 ejection case and the 1993 compromise agreement between Locsin and the occupant. Yet he still bought the land from Mary Lou Bolos, a woman who had never even set foot on the lot. Locsin was the one actively suing the occupant in 1992. Bolos, who supposedly bought this land way back in 1979, did absolutely nothing to assert her rights for decades. Which logically begs the question, right? If Bolos bought the land in 1979, why on earth was Locsin the one suing an illegal occupant in 1992? Entering into a compromise agreement to oust someone is an act of strict dominion. If Bolos actually owned it, she should have been the one filing the suit. The Supreme Court pointed out that this glaring inconsistency should have immediately set off alarm bells for Bernardo and Carlos Hizon, but instead of investigating, they just willfully closed their eyes to it.
Section 4, the suspicious sibling sale and the 15-day cover-up. 15. That is literally the number of days it took for Carlos Hizon to flip this property. On May 9, 2002, Locsin's counsel sent Carlos a formal demand letter clearly stating the title was forged. And a mere 15 days later, on May 24th, Carlos suddenly sold the property to his sister, Lourdes Guevara, and her husband. The Supreme Court saw right through this whole charade. First off, Bernardo acted as the agent for his son Carlos. In law, the principal is bound by the acts of the agent. So Bernardo's knowledge of the title's flaws is legally imputed directly to Carlos. Second, there was a total lack of consideration. During the trial, neither Carlos nor Lourdes could produce a single document, contract, or cleared check proving the alleged 1.5 million pesos. Nothing. Third, they're siblings. The idea that Lourdes didn't know about Locsin's legal claim is highly, highly incredible. And finally, the Guevaras immediately mortgaged the property for 2.5 million pesos, but they never actually used the credit line. The court easily recognized this mortgage was just a dummy ploy to make it look like the Guevaras were exercising acts of normal ownership.
Section 5. Precautions for land buyers. The Domingo Realty Checklist.
Now, if you are a legal practitioner advising clients, you need to pay close attention to this part. The Supreme Court laid out the exact standard of diligence required, citing the case of Domingo Realty Inc. v. CA. To actually claim the protection of an innocent purchaser for value, especially when red flags exist, buyers have to take these precautions. You need to verify the title's origin with a register of deeds. Engage a geodetic engineer to check the meets and bounds. Conduct a physical ocular inspection of the lot. Talk to the adjoining owners about the true ownership. Put up visible signs stating the lot is being purchased, and undertake public notice measures. The Hizons and Guevaras failed to do practically any of this, which completely barred them from invoking the Mirror Doctrine.
Section 6. The Supreme Court verdict, returning the stolen land. After a decade of litigation, the Supreme Court finally delivered its ruling. They reversed the Court of Appeals. The forged titles descending all the way from Bolos to Hizon to Guevara were declared absolutely null and void. But let's talk about the damages, because there's an important nuance here regarding evidentiary rules. The court actually denied moral and exemplary damages. Why? Because Locsin failed to specifically plead or present concrete evidence of physical suffering or mental anguish during the trial. You have to prove it. However, the court did award 75,000 pesos in nominal damages. As a matter of law, nominal damages are awarded to vindicate a right that's been violated, not to indemnify a proven loss. Her property rights were unlawfully invaded for 10 years, so this was perfectly appropriate. She was also awarded 75,000 pesos in attorney's fees. So the Locsin versus Hizon ruling is just a stark jurisprudential reminder that the Torrens system is not a license for willful blindness. The law absolutely protects the innocent, but it definitively does not reward the willfully ignorant. So I'll leave you with this question to think about. When a title looks perfectly clean on paper, are you bold enough to dig up the dirt buried underneath? Thank you so much for joining me on this explainer. Keep questioning the surface and always verify the foundation.